on the record in the matter of the state of Michigan versus Cadence Blundell, 24-02054. Appearance, please.
Hearing for Attorney Gill on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Blundell, who is standing to my right.
Okay, Ms. Blundell was supposed to have a violation of probation hearing today. However, it looks like to be arraigned on a new violation.
That is my understanding, Your Honor. I had a brief chat with Ms. Bayless out in the hallway to see what the violations allegedly were and if there's any change in recommendation. She said minor, but I haven't been able to see the new paperwork she submitted yet.
Okay, I have a request and summons for probation violation. Looks like it was signed by Judge Flores on my behalf. It may help to take the signature, but on June 9th, it says the defendant failed to refrain from alcohol per Cordant Health Solutions on or about May 14, 2025. There was a positive alcohol result yielding 6,358 nanogram per milliliter ETS. And then on May 23rd, 2025, a positive alcohol result yielding 5,554 nanogram per milliliter ETG and 2,001 nanogram per milliliter ETS. You have the same right as it relates to these two new violations. You have the right to be represented by an attorney and the right to have a contested hearing. If you're found to be in violation of your probation, you can be sentenced to a term of jail time. You understand that?
Yes, Your Honor.
How does she want to proceed on this?
Well, Your Honor, I don't believe there's gonna be a contesting of these violations. If it's possible, Ms. Bayless did tell me just a few minutes ago in the hallway that there is a slightly amended pink sheet with the file that I haven't had the opportunity to see. Would it be possible to review that with Ms. Blundell very briefly before we proceed?
A slightly, you're talking about the probation recommendation?
That's correct, Your Honor. She indicated to me in the hallway she's made a couple of changes since the last one back in May that she submitted.
This is last dated. It looks like it was from originally April 28th, and she put April 6th. I'm sorry, June 6th on here. So this must be the violation. It's more than slightly violation. That's why I'm looking at that. But let's see.
She kind of verbally told me some of the things she had newly indicated on a new pink sheet. I don't know when she was saying that pink sheet was submitted though, but I just have the one dated April 20.
You have a copy of it or you don't?
I have the copy from April 28th, but Ms. Bayless told me about 10 minutes ago that she was making a new one or had already made a new one. Thank you. And as opposed to resetting this out again for another future date, I think we can potentially handle this. I just would like the opportunity to review it very quickly with Ms. Blundell. Thank you, Your Honor. I think we're ready to proceed today.
First one, proceed.
Thank you, Your Honor. This will not be, we will not be contesting the violations today.
She wants to plead to the violation.
That's correct.
That's correct. Ma'am?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, Your Honor.
Okay, you can put your hand down. I'm just trying to understand my note.
You are no or.
My note. Yeah. Because my note from the 19th was for her to engage in outpatient service. I don't know why that's the recommendation. That's,
I think I have a little bit of background on that. So we didn't actually have any hearing on the 19th because there was a jury trial going on, so we just rescheduled everything there. But I believe at that time, Cadence was already talking to Jody about getting involved in an outpatient, so they started talking about insurance and everything, and that continued into a conversation 4 days ago. And I suspect Jody was saying at that time they're already working on getting her in, and she's brought insurance information to go downstairs and talk to Jody next about that.
well, it looks like I arraigned her on the 19th, so we weren't scheduled to have a hearing because I put defendant pled not guilty. The hearing was June 16th at 1:30, and I ordered her at that time to engage in outpatient services.
I believe that was a similar situation to today, where there was a hearing scheduled, but then a new violation that she was arraigned on instead.
Oh, got it.
And I believe that was the alcohol test from 4/21.
Okay, you understand that if you're found to be guilty of these violations, or if you plead guilty to the violations, that you are subject to a penalty, including possible jail time.
Yes, Your Honor.
And I could extend your probation. I can also give greater oversight conditions and impose additional treatment. You understand that?
Yes, Your Honor.
And you still want to waive your rights, understanding that?
Yes.
As to the violations that I just read, which was from May 14th and May 23rd for positive alcohol results, how do you plead?
Yes, Your
As to the violation you was arraigned on back on May 19th for failed to refrain from alcohol on about April 21st. Positive results yielding 247,446 nanogram per milliliter and 104,000 nanogram per milliliter ETS. How do you plead?
Honor.
as to the violation that you were arraigned on May 5th for failure to refrain from alcohol with on or about April 16th with a alcohol result yielding 6,033 nanogram per milliliter of 25-24 ETS. How do you plead? Factual basis.
Thank you, Your Honor. Ms. Blundell, is it true that in January of this year that you underwent sentencing in front of Judge Simmons? And at that time, she explained to you all the conditions of probation that you would have to follow,
Yes,
and that included not to consume or possess alcohol?
yes,
And is it true that at the previously listed dates in April that you did consume alcohol?
yes,
And that led to positive alcohol results while testing at Courtroom?
yes,
And that's in violation of the conditions of your probation?
yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the prosecution?
None, Your Honor.
I would accept your plea and find your plea to be voluntarily and intelligently made. The recommendation, which I think your attorney just went over with you, it states for there to be an extension of your probation of 6 months, impose a weekend in jail, and then add outpatient treatment and increase monthly supervision to 2 times a month. Says the overall attitude has been fair, acceptance of responsibility for and overall progress is poor. You can make allocation.
Just to correct, Your Honor, the overall progress was circled fair.
Overall attitude fair, acceptance of responsibility poor, overall progress fair.
Thank you, Your Honor. Yes, I think Jody and I have had a few discussions with Ms. Blundell recently. And what she's told both of us is that she is struggling. She comes from a long line of addictive personalities. She's surrounded by family members who are in active addiction and crisis. And that's something that she's trying to get herself out of, but it's difficult when it's into her entire family. To that end, she's recently moved out of her mother's home and is residing with a friend now to try and get out of that situation. Still stumbling, still struggling a little bit, which is unfortunately the nature of addiction. She did ask for more supervision. She wants more rigidity, more oversight, more structure from the court to keep her progressing forward. And that's a bit of an unusual request, but I think it says a lot of her desire and effort to commit to sobriety, to get sober and then to stay sober here. And in my discussion with Ms. Bayless before court today, I think it's something that she's very willing to engage in with her to provide her with this support and stability and rigidity. I do think outpatient is appropriate and fair, as does Ms. Blundell. She's been working with Jody for the last month or so on getting into it. Specifically, Katie's has talked about getting into reality counseling's program. She's observed one of their classes in the past, really enjoyed the discussions there and the observations she was able to have. And so she's working with Jody on getting involved in that programming and has brought her insurance information. She's headed downstairs today to talk with Jody about doing that. I would ask the court to consider holding the weekend in jail in abeyance to see how she's doing once enrolled in that outpatient programming. I think it's worth giving Ms. Blundell the chance to see if she can make or break when she's into the programming, something that she's been lacking in the past. And it's something I think she is capable of taking advantage of if she's given the chance to do so. I would also ask the court to increase the monthly reporting with Ms. Bayless to 2 times a month. I think it's a good structure for her that allows her the chance to touch base with Jody more often and touch base with herself more often on continuing the sobriety. And outside of that immediate weekend in jail, I would ask the court to adopt the recommendation.
Ms. Blundell wishes to say anything.
No, Your Honor.
I think part of the concern that I have is the amount of violations that I've had in this time period. I can appreciate the probation department being willing to work with Ms. Blundell, but I, in this particular case, find that this particular officer has been quite lenient more lenient than I've ever seen her with people with fewer violations. So that's a concern. I'm reviewing the pre-sentence report and recommendation. Says nothing about a recommendation that Ms. Blundell would benefit from outpatient treatment.
I agree with that observation, yeah.
Problematic for me, because if that were, if what we had at the time was that she has an environment that she's in, which is information that should have been uncovered in the pre-sentence interview, that puts her at a disadvantage. You know how many people I see come through here that have those same situations, but now it's highlighted, so that we can give her special consideration. I have no problem with taking that into consideration. I would like that highlighted for other disadvantaged groups, not just in this particular case. And I cannot at any time discount, Ms. Blundell, the amount of times that you have violated my orders of probation and the amount of leniency that I've given you even outside of that. I have adjourned things to let you bring things into compliance, extended things out. The last 3 times you've been here, we've not been able to move forward with the violation because there was a new one pending. And so I can understand that you do have some hurdles in your personal life and the environment that you're in. And I think I told you multiple times, you look very young, but you are an adult now. And at some point, you have to take onus and responsibility for your actions and even the environment that you're in, so that you can do better. There are individuals that have been in similar or probably worse situations with you that were able to turn their pattern or their pathway a different way, but it was because they were determined that they were going to do that. That's up to you. You can't use this history that you have in your family, the drug or substance related issues in your family as a crutch for you to engage in poor or bad behavior. Okay, you knew you were on probation. You knew you had orders that you were not to drink, and you still took those drinks, correct?
Yes.
Okay, so that's up, this is on you. This is not on them. I'm going to give you an opportunity to continue on probation. It will not come, and I will also grant your attorney's request. I'm not going to put you in jail right now because this is your last chance for me. You blow this one, you're doing the full 93 days in jail.
I understand.
And there's zero amount of empathy I will be able to give you if you throw this last chance away. We have bent over backwards to assist you. And part of my hesitation of putting you in jail is that you look like a 12-year-old child. And I fear for your life and your safety if you go into a jail. I don't think you'll come out the same. That's a fear you should have for yourself. You should think about that fear next time you're deciding if you're going to take a drink or not. That you could be sitting there in jail, putting yourself at risk. There will be no one to hold your hand and protect you 24 hours a day. You understand that?
Yes.
And the alcohol, it can't be worth your life and your safety.
I understand.
Some of these alcohol levels, even if you didn't go to jail, you're putting your health at risk. These are some extremely high alcohol levels, especially for someone your stature. You understand that? So I want to see you get the help. I wish that it was advised or picked up earlier on that you needed some outpatient treatment. I did order it about a month ago. It looks like we're getting on track to get that in. Go ahead and extend your probation 6 months. Here to follow the clear black letter of my order. I know there will be, payments need to be made, and I'm not waiving the oversight fee. You're gonna pay the oversight fee for this additional 6 months. And especially considering it's gonna take all of a sudden more time for you to be supervised. There won't be a waiver of that time. You're gonna pay the oversight fee for that. Increasing your meetings to 2 times per month with your probation officer. The next time I see your name come across my desk, it needs to be an indication that you need to be successfully discharged. Otherwise, you'll serve 93 days in jail. Do you have any questions?
No.
We'll check in with Ms. Bayless before you leave here today. Any additional matters for the record?
Nothing on behalf of people.
Nothing further, thank you.
You can hold it, it's just ongoing file. You should be there.
Thank you, Your Honor.
Thank you. On the record in the matter of the state of Michigan versus Harry Jackson, 24-02465. Okay, Mr. Jackson, we have a request and summons for probation violation. The request here states that you violated the order of probation there was a scram tether confirmation of a consumption on May 10th. That began at 3:02 a.m. on May 10th and ended at 2:29 a.m. on May 11th with a TAC of 0.084%. So you have the right to have a contested hearing, the right to be represented by an attorney at that hearing. If you're found to be in violation of your probation status, your probation can be revoked and you can be sentenced to a term of jail time. Do you understand that, sir?
Yes, sir.
Would you want to request an attorney to represent you?
No, I'm going to clean up right now.
I'm gonna appoint an attorney to represent you on this.
I'm trying to go to jail. Because
I'm telling you to be quiet. There's a reason why I'm doing this. The same probation officer that I just had, recommendation is to send him to jail. Okay. And that's the point I'm making.
Yeah, fair.
You have the right to be represented by an attorney. So I'm going to appoint an attorney in this particular case so that you can be properly advised. Recommendation is terminate, sentence to jail. Says he's been on probation since December, not as long as the last person. It's made zero improvement. Same exact issue. Not a problem. I'll set it for a hearing because you're going to meet with your attorney so that they can properly advise you, okay?
So I can't speak right now.
You have, no, you're not, I'm not allowing you to speak.
Oh,
I wouldn't recommend that.
June 30th at 1:30 is your hearing. I need that file back. Did you send it downstairs?
Yeah.
We'll get you a notice for your next court date. And then you can meet with her privately, okay?
Thank you.
For the record, in the matter of the state of Michigan versus Daniel Devliger, is that yours or Miss?
That is it, Your Honor.
File number 24-03104, appearance, please.
Haley Fortuna Gill on behalf of the people, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Devliger, who's standing to my right.
Mr. Devliger was scheduled for a hearing on a probation violation. How are we proceeding?
Your Honor, the people cannot meet their burden at this time, so they would ask that this be dismissed.
I would ask the court to follow that recommendation, Your Honor.
This was based off of the police report, is that what you're saying?
That's correct, Your Honor.
It'll be dismissed. I'm gonna remind you, did you know that you're not to be in possession of a firearm or any other dangerous weapon? Okay. You're all set. You'll continue with your probation.
Thank you, Your Honor.
Mr. Jackson had another one, or is it the same thing? It's on each one. Got it. Oh, no, he has another file. That's what it is. I don't know what this is. I'm sorry, what? Meant to say. Same. Okay, this is the state of Michigan versus Francisco Casino, 24-03223. Francisco Casino,
You doing, Your Honor?
I'm well, how are you? Okay, I have here a request to summons for probation violation, and the allegations are that you violated your probation by testing positive for alcohol on May 9th, confirmed on May 16th. With the ETG greater than 25,000 nanogram per milliliter and an ETS of 6,538.8 nanogram per milliliter. You have the right to a contested hearing and the right to be represented by an attorney at that hearing. If you are found to be in violation of your probation, you can be sentenced to jail. Do you understand that? You also could have your probation extended, or I can give additional oversight or programming. Do you understand that? For sure. Do you want an attorney to represent you? Set this hearing,
June 30th at 1:30.
June 30th at 1:30. Okay? I'll meet with the public defender today so they can get information from you, okay?
Okay.
Thank you. Did we lose Mr. Jackson?
Yes, he's in the room. Did you want?
He does need to come back because, yeah, I didn't know he had two files and she didn't put the full violation on the second file. He just had another confirmed violation.
I know Mr. Rowley filled out an application. He might have gone.
Oh, that's fine. That's all the probation. Are you ready on any pre-trials? Oh, no, we should have one more, but.
Advise William and Tyler is here. I'm just trying to find him.
Oh. I got that email like moments ago.
That's fine. It was just another confirmation.
Yes.
Oh,
he is.
okay. Oh, okay. He's not out here.
Just that one, the other one.
I'm sorry?
For Jackson.
Mhm.
Would you mind putting me into a breakout room with Tyler?
Oh.
On the record, in the matter of the state of Michigan versus William Tyler, 25-01572. Appearance, please.
Haley Fortuna Gill on behalf of the people, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Tyler, who joins us via Zoom.
Okay, Mr. Tyler has a domestic violence pretrial. Today, is there a offer?
There is no offer at this time, Your Honor.
How do we proceed?
Your Honor, Ms. Fortuna Gill conveyed some information to me a little bit earlier today. We'd like to look into that, so we'd be asking for an adjournment of today's hearing as opposed to a typical final pretrial, so we can figure out what's happening here. It doesn't need to be a very long one.
Where are you looking into? Discovery? Or
There is a police report
Okay.
that's,
For further discovery?
Yes.
Thank you. We can do July 14th at 10. July 14th at 10.
And is Zoom still okay for Mr. Tyler at that time?
Correct. For any pretrial. Mr. Tyler, do you have any questions today?
You said July 14th at 10,
That's correct.
and it's in person or on Zoom?
That's gonna be via Zoom.
Okay, that's the only question I have.
Okay, you're all set. Thank you. The state of Michigan versus Darval Thomas, 25-01415.
Haley Fortuna Gill on behalf of the people.
Jacob Riley on behalf of Mr. Thomas.
Mr. Thomas is scheduled for a pretrial, the charge being domestic violence. Was there an offer on this?
There is no offer at this time, Your Honor.
Requesting final pretrial later on.
July 14th at 8. September 8th. at 8. Final pretrial, July 14th in person at the court, and then jury trial September 8th, 8 a.m. in person at the court. Do you have any questions today, Mr. Thomas?
This one.
This court. Have any other questions? We'll get you a notice to appear. Any additional matters for the record?
Nothing, Your Honor.
No, Your Honor.
You're all set. Ready? On the record in the matter of the state of Michigan versus Peter Gifford, 16-03286, appearance please.
Haley Fortuna Gill on behalf of the people.
Jacob Riley on behalf of Mr. Gifford.
Mr. Gifford was a assault or assault and battery. This is the one that he just got the president.
Yes.
Okay. We were setting this for final pretrial.
That would be our request. Your Honor.
Final pretrial July 14th. Jury trial September 8th. Final pretrial, Mr. Gifford is going to be July 14th, 8 a.m. in person at the court. And then your jury trial, if this proceeds, will be on September 8th at 8 a.m. also in person at the court. Do you have any questions at this time?
No, you're right.
We'll get you a notice to appear. Any additional matters for the record?
Nothing.
No, Your Honor.
Angie Green here.
No.